All right, good afternoon, everyone. We're back on the afternoon docket. I'm Judge Jackie Powell. I'm going to start with the first appearance docket. And for those of you who are here for first appearance, I am going to let you know whether or not I found probable cause to detain you. And then we'll also talk about release conditions. Today's not your trial, so when you come up, you don't want to talk about your case because everything in this courtroom is being recorded. You do, for those of you at the main jail, there is an attorney from the Public Defender's Office there. If you are represented by the Public Defender's Office, he will assist you. And I also have an attorney from the Public Defender's Office here in the courtroom with me as well, Mr. Brian Reedy, as well as the State Attorney, Attorney Eric Linder. So when I call your name, please come up and we will address each of you individually. Eileen Dukakis.
She's approaching, Judge. She's here at Maine. Come on up, ma'am.
Mr. Dukakis, good afternoon.
Good afternoon.
You're before the court today for one count of leaving the scene of a crash. Count 2 is a DUI, alcohol. Count 3 is DUI with, counts 3 and 4 are DUI with property damage. And count 5 is a felony violation of probation. That's a no bond hold on count 5. I do find probable cause. Does the parties wish to be heard as to bond?
Judge, considering she has a no bond hold at this time, nothing from the defense, Judge.
All right, so the standard bonds will remain in place. Good luck, ma'am. Madam Clerk, now because we don't have the carbon copies today, do you want me to sign each one? Because I think the machine is broken, we have three separate sheets as opposed to the carbon copy. Sign each one? All right. I could probably get the old-fashioned carbon to put between the pages. Am I dating myself? Sorry. All right, next person, Caitlin Tampori. Caitlin?
Judge, she bonded.
Okay, thank you. Next, we have Haley Allison.
She's in North Broward, Your Honor.
All right.
I'll be asking for pretrial release for Miss Allison.
All right, Haley Allison. Ms. Allison, good afternoon. You are before the court today for count 1, aggravated assault with a deadly weapon without intent to kill. Count 2 is touch or strike battery. Count 3 is criminal mischief. And count 4 is resisting officer without violence. I do find probable cause.
I don't know if the state has an objection to pretrial release for Miss Allison. I do. Judge, she's been living here for 20 years. She works as a waitress. She had 72 hours toward her degree at the University of Texas. She has a place to stay. She has a stable residence. She knows the victim in this case. They are not strangers to each other. She also received several injuries at the wrong end of the baton that was used in this case. I think that there may very well be a self-defense claim raised here as the facts of this case come to light, especially, as I'm told, when we have the opportunity to review the video that was taken of the incident. I know that she has had some contact with the criminal justice system in the past, but based on the length of time that she's been living here in Florida, I do not believe that she is a flight risk. She agrees to stay away from the alleged victim in this case and not have any contact with him.
The officer reviewed or the deputy reviewed the video, and he made a determination based on his investigation to charge her with these offenses. Ms. Allison is currently on probation before Judge Carpenter Toy for battery. Among her probation conditions are, including an anger management class, no alcohol or intoxicants, and I would note both the alcohol influence and drug influence box are both checked off with respect to Ms. Allison in this matter. Additional priors: theft last year, DUI 2015, resisting without violence 2014. I'd be requesting a $2,500 bond on count 1 in order of no victim contact.
Okay.
Fact remains, Judge, that based on my conversation with Miss Allison, I don't believe she's going to be able to get any kind of a monetary bond.
All right. These allegations are a bit serious, and with the prior battery, pending battery before another court. I have to take all of that into consideration. And so as to count 1, I will impose a bond of $1,000. I'll do $1,000. And no other conditions at this time.
Leon, no victim. I'd ask for
No victim contact.
Thank you.
All right.
Good luck, Miss Allison.
No, the other ones that don't require a bond, I'm not going to impose it. All right, good luck, ma'am. Dominique Thornton.
She bonded, Judge.
All right, thank you. Joel Miller.
Mr. Miller's here at Main, Judge. He's approaching.
Mr. Miller, good afternoon, sir. You're before the court for 1 count of DUI. Count 2 is refusing to submit to DUI test. Counts 3 and 4 are traffic infractions, careless driving and unlawful speed, not for magistrate. As to counts 1 and 2, I do find probable cause. Does the parties wish to be heard as to bond?
I do, Judge.
Okay.
I'm speaking to Mr. Miller. Unfortunately, right now, he doesn't have any phone numbers memorized, and but he does have his phone in property, so he's going to attempt to contact people. But from what he advised me, he doesn't think nobody has the financial means to post his monetary bond. So ultimately, I'm going to be requesting the court consider releasing Mr. Miller on pre-trial release. Now, he's been living in our community his whole entire life. He is 50 years old. He's on disability. He gets $771 per month. He's a registered voter here in our community, Judge. And from what he informed me, he's been volunteering for a number of years at a certain dog park where he helps there. He lives in Oakland Park in an apartment he's been renting for the past 3 years. His monthly rent is $458, but the most important thing that's on Mr. Miller's mind is right now, unfortunately, his service dog is home alone, and that's what he's really worried about. I can't feed him, can't water him. He wants to go home right away so we can give him food and water, but that's what's on his mind, Judge. So we're going to be asking for pre-trial release on Mr. Miller's behalf. Now, I do understand that he does have priors, but from my understanding, speaking to him, he's been 5 years clean. So, Judge, he assures me he's going to come back to court. He's not a flight risk at all. He has strong ties to community, Judge. He just wants to be released and supervised so that he could be there for his dog.
Your Honor, I have no...
I'm sorry.
No, I'm sorry, I just read something. I have no objection to pretrial with random testing.
Okay.
Thank you.
All right, I'll grant the pretrial release supervision with random testing. Good luck, Mr. Miller. Charles Bush.
Mr. Bush is here present, Judge. It's a municipal ordinance case.
All right. Mr. Bush, I'll recall your case when the attorney gets here, okay? Just
All right.
hold on just a moment, okay?
They're waiting on the city public defender. Have a seat, sir.
Rosario Panaccio.
Mr. Panaccio is here present at Maine. Come on up, sir.
Mr. Panaccio, good afternoon. You're before the court for one count of resisting officer without violence. Count 2 is fleeing or attempting to elude law enforcement. Counts 3, 4, and 5 are traffic infractions not for magistrate. I do find probable cause.
Judge, nothing to add from this defense at this time. He did give me the phone number of several friends and family who I intend on calling after court. The only thing, just in case, I'm going to be asking for a photo order.
I will sign the photo order, and the bond on count 2 is $1,000. Good luck, sir. Chris Tobar.
Mr. Tobar, if that's what you call bonded.
Yes.
Bonded, Judge.
Bonded. Thank you. Edward McLeod.
Mr. McLeod, bonded, Judge.
All right. Emmanuel Walker.
Mr. Walker is here present, Judge. I mean, he's approaching. Come on up, Mr. Walker.
Mr. Walker, good afternoon, sir. You're before the court for one count of disorderly conduct and count 2 is resisting officer with violence. I do find probable cause. Does the parties wish to be heard?
I do, Judge. And being Mr. Walker, he's looking forward to his day in court. But having said that, Judge, we're going to be requesting an ROR on his behalf. He's 20 years old. Right now, he's studying at Kaiser University. He's a junior. He's pursuing a criminal justice bachelor's degree. What he wants to do, Judge, is he eventually wants to apply for the FBI. He pays through school for 3 different ways. He has a grant, he has scholarship, and then whatever outstanding balance, he gets financial aid. Now, he is living on campus. He lives in the dorms. Judge, from my understanding, he has a clean record. He will be coming back to court. He doesn't want to jeopardize his future. He wants to have his future in law enforcement. So, Judge, that's why I'm requesting an ROR on Mr. Walker's behalf.
Okay. All right, Mr. Walker, I'll grant the ROR. And during the pendency of this case, no return to Sway nightclub. Good luck, sir.
Thank you. Good luck, sir.
Yes. All right, we're back on the record. Miguel Flores.
Judge, he's not here at Maine. My understanding is the VOP. He was reset for tomorrow to appear in front of the division judge.
Okay. Do you have that information? Okay. All right. Rashid Woodward.
Mr. Woodward is here present, Judge at Maine. Come on up, sir.
Mr. Woodward, you're before the court for one count of possession of heroin, and count 2 is a traffic infraction not for magistrate. Count 3 is a misdemeanor capias. There was a bond that was set by the judge, the previous judge, for $500. This is a capias from last year, March 2018. So, as to count 1, I do find probable cause.
Hey guys.
Does anyone want to be heard on the bond?
Yes, Judge. As far as in reference to count 3, the capias for the trespass, from what Mr. Woodward advised me, he didn't voluntarily miss court. He never received notice. He didn't know he had to go to court for that case. And speaking to a judge, he works for a labor pool. As you know, it fluctuates as far as whenever there's employment. He doesn't have the financial resources to post his bond. He lives at a facility called Village Group Home. He's been there for about 8 years. He's 27 years old. Judge, in reference to this count, I believe this stems from basically riding a bike at night without a light. That was the, I guess, basis of the encounter. Judge, we're going to be asking for the court to consider releasing Mr. Woodward on pretrial release.
Okay.
Your Honor, I don't have an objection with random testing. He has a lot of previous arrests.
Okay. All right, Mr. Woodward, I will release you to pretrial supervision, and that will include random testing. Yeah, and count 3. 1 and 3. Wilmer Rojas Gamboa, is that the one we're waiting for a Spanish interpreter?
I believe so, Judge, yes.
Is this the case from last Friday?
Yes.
Were you able to, did you get information?
I'm familiar with what's going on in the matter, Your Honor.
Okay, all right. All right. Keith Goss?
Mr. Goss is here, Judge, at Maine. Judge, I waive formal reading of the charges.
All right, I do find probable cause. As to bonds?
Your Honor, one moment. I'm requesting a $5,000 bond on count 1 and 2.
Okay, Mr. Romero? Judge, I didn't hear, what was the, on count 2, what was the state, recommending? I know on count 1 they said 5.
And 5.
I didn't hear. Oh, 5, 5, and 5? Okay. Judge, and speaking of Mr. Goss, he's not going to be able to afford $10,000. He's going to be reaching out to his father, and he's elderly on a fixed income and retired, gets Social Security. He believes at most, if the bond was set at $2,000 on each count, he could come up with the premium using the services of a bondsman. Now, Mr. Goss is 41 years old, been living in South Florida about half of his life. He's been clean and out of trouble now for almost 20 years. He lives in Lauderhill. He works at 2 different jobs, Judge. He works at a place called Mannheim Auction, where he's a porter. He's been there employed for 3 months now, making about $8.50. And he's been working security for the past 6 years. Makes approximately $85 a day when he works there. So, Judge, from Goss advised me he's not going to be able to post his monetary bond. That's why he's counting on his father. So that's why we're requesting $2,000 bond on count 1, $2,000 bond on count 2.
All right, granted. 2,000 on each count. Isaiah Washington.
Mr. Washington, come on up. He's here present. He declined the service of public defender, Judge.
Mr. Washington, good afternoon.
Hello, how you doing?
I'm okay. Have you hired a private attorney?
Not as of yet.
Okay. But you don't wish to use the attorneys from the public defender's office?
I mean, I could use them right now. I don't need them right now.
You need him or you don't need him?
I need them right now, yeah.
All right, then you need to speak to him for a couple of
I
minutes.
do, Judge. Could I have a moment, please?
Sure.
Very much.
Well, Mr. Romero, well, I guess we can wait for Mr. Washington to come back, but just to let you know, I have a probable cause argument as to count 1.
Mr. Washington?
Yes, Your Honor.
Okay.
Judge, thank you for giving me that opportunity. We're ready to proceed on Mr. Washington.
Okay.
Yes, Judge, I would make an argument that there's no probable cause to support count 1, carrying a concealed firearm. According to the probable cause affidavit, the officer arrives. There are several people around the vehicle. He says he sees Mr. Washington in the rear driver's seat of the vehicle, and later, upon a search of the vehicle, a firearm is found underneath the driver's seat. We don't know if Mr. Washington is the owner of the vehicle. There's no indication of that. He was never seen driving the vehicle. We don't know how far under the driver's seat of the vehicle this firearm was. There's nothing in this report to indicate that it was in plain view. And if it was in plain view, I certainly think that would be the kind of thing an officer would put in his report. So I don't think Mr. Washington can be held accountable to have knowledge of what is underneath the driver's seat of a car that doesn't belong to him. So I do not believe that there's probable cause to support count 1.
But wasn't it Mr. Washington who was sitting in the driver's seat?
He was in the rear driver's seat, according to the report.
The rear?
Yes, ma'am. And there
The
were other
interior,
people
the
all around the
contact
vehicle.
who was sitting inside the vehicle. So, speaking to the defendant, I observed a black hand on the floorboard of the vehicle directly underneath underneath the front driver's seat.
Right, so the allegation would be that the firearm was underneath the seat in front of Mr. Washington, which is not enough to establish, from my perspective, a probable cause that he knew the gun was there or should have known the gun was there. Certainly no fingerprints were taken from the gun that could be compared to Mr. Washington's. He was never seen in possession of the gun. We don't know who put the gun there. We're not exactly sure where the gun is.
I think we got the argument the first time, Your Honor. I'm not, that's fine if the court finds no PC. I'm not asking for any time.
I finally wore you down, Mr. Lender?
No, it's just I heard it one time. I heard 2, 3, 4 more times. I get it.
So, as to count 1, we'll find no probable cause. Count 2, there is a finding of probable cause. As to bond?
Judge, in reference to count 2 with the $1,000 bond, nothing to add from the defense.
Okay. All right, so the bond is $1,000 on count 2. Okay. And then Philip Jean Joseph.
Mr. Joseph? He's here present, Judge at Maine. My understanding is he may have bonded.
Is Mr. Jean Joseph bonded? All right.
Yes.
I hear a yes.
Yes, he did, from what I can tell.
All right, so Mr. Jean Joseph, you're before the court for 1 count of possession of cannabis over 20 grams. And I do find probable cause, and your bond has been posted. Good luck, sir. All right, then we can go to the hearing docket. The felony hearing docket. All right. Jared Heiss. Do we have Jared Heiss?
Conti facility, Your Honor.
Okay. All right, Mr. Heiss is before the court for a 30-day motion for ROR.
State has not filed information at this time. Mr. Heiss is entitled to an ROR on these charges.
All right, Mr. Heiss, I'm granting your motion for release, and it doesn't mean that the state can't file the charges, so you need to pay attention to your mail so you can know whether they filed the charges, and if they have, when you have to come to court. Good luck, sir.
Thank you.
All right. Then we have Leslie Harris.
All right, Your Honor.
All right. Mr. Harris is also before the court for a 30-day motion.
State has not filed an information,
Miss Harris, I'm sorry.
Yes.
so Ms. Harris is entitled to an ROR.
Okay, Miss Harris, I'm granting your motion for release.
Yes.
And please make sure you check your mail so that you know if the state has filed the charges and if you have to come back to court, so you won't miss those times and dates, okay?
Okay, thank you.
All right, good luck. Darius Quinn.
North Broward.
All right. Mr. Quinn was arrested on February 28th, and so he's before the court for a second look on his bond status.
That's correct, Your Honor. Mr. Quinn has a $1,000 bond on this possession of cocaine charge. I'm going to be asking the court for pretrial release. He's lived here all his life, and he's currently living at Broward House. And from what he indicates to me, he has a key to his room at Broward House. He's trying to deal with his substance abuse issues. He does have some contact with the criminal justice system in the past. He also has a medical condition for which he is not receiving medication in the jail. And it's the kind of medical condition that if you stop taking the medicine, things can get very bad very quickly. So in light of the fact that he has extensive ties to the community, has a stable address, and is living basically in a rehab facility, I'd ask the court to place Mr. Quinn on pretrial release with a special condition that he submit to random drug tests, which they do at Broward House anyway.
Okay.
Your Honor, my first thought upon hearing that, I can't imagine cocaine is good for whatever his medical condition is.
Yes, I think that Mr. Quinn realizes that also.
Well, his last arrest, it was on a theft, but at that time there was also an outstanding warrant for drug paraphernalia, and that was last year, showing paraphernalia last year. Trespass last year, he's gone to state prison, 2015, aggravated assault. Jail on multiple other theft-related offenses. Nothing further, Judge.
Great. I was not able to, I don't know the circumstances. I don't have the paperwork to refresh my
It was
recollection of the circumstances surrounding the,
he was seen sitting down in the front of a door of an abandoned residence. Law enforcement saw that he had something in his hand. He attempted to conceal it. This is a high narcotics area. One moment.
This was not at Broward House, right?
No, I don't believe so.
All right,
It
so
was an
I'll,
abandoned property.
oh, thanks. Okay. All right, I'll release Mr. Quinn, but I'm gonna do level 2. Oh, sorry. And with random testing. Well, he gets random testing at Broward House? Is that part of,
Yes, it is, Your Honor.
Okay, all right, so then I won't add that. Yes.
All right, good luck, Darius.
Thank you, sir.
You turn it around.
Thank you, Judge.
Okay.
You're welcome, sir. Thomas Jefferson.
North Broward.
No problem.
Did we get help from Mr. Jefferson? Was it, someone was going to, someone was gonna find out where Mr. Jefferson could go. I do remember this. Mr. Jefferson was arrested on 2/28, and he's back before the court for a second look. There were some mental health concerns as well.
I believe that our office has, pursuant to my request, flagged Mr. Jefferson as a potential mental health consumer. Let me see if anyone has done anything. My internal computer is not working this afternoon.
All right.
I think they're reloading it to a different database or something, so I really can't bring up my own personal records or our office's records on this to advise the court as to what progress may have been made. Mr. Jefferson, has someone from our office come to speak with you?
No.
All right. Judge, maybe we could, I know it's a second look, but maybe we could reset him for tomorrow so I can look into it a little bit more.
Okay, because, you know, I know that I definitely remember this and that I had concerns. So I'm not going to make any changes today. If I can reset it tomorrow if that's what.
I would ask
give
that you do,
time.
Judge.
Okay.
Because I don't want him to just kind of, slip through the cracks. I want to make sure that
Right.
that our office is on top of the situation.
Okay. All right. Mr. Jefferson, your attorney will talk with you. Kimberly Merville.
She bonded.
She bonded?
Yes, ma'am.
Okay. Lorenza Cochran.
Mr. Cochran is here at Main, Judge. He is approaching. Come on up, sir.
All right, Mr. Cochran was arrested on 2/28. So he's here for a second look.
Yes.
Correct, Judge. When Mr. Cochran came in last week, I didn't ask the court for anything. Mr. Cochran gave me the phone number of his friend to help post his bond. And unfortunately, I've been unsuccessful in trying to get his friend. So, Judge, at this time, I'm going to be asking for the court to consider releasing Mr. Cochran on pretrial release.
See, I thought Mr. Romero might have known, and that's why I didn't ask for anything. Mr. Cochran is out on bond for domestic violence battery at the time of this arrest.
All right. So I'm going to deny that.
Judge,
Initial
is that, in speaking to Mr. Cochran, he thought that case of Ready may have been dropped. Is it still pending? Is it still an open case, or has it been? Oh, wait, which?
I don't know.
I will check.
Thank you.
No, he's got a calendar call for March 27th before Judge McHugh.
All right, Joel Sizer.
He's coming up.
All right, Mr. Sizer is before the court for a second look. He was arrested on February 28th.
Yes, at the time of this arrest, Your Honor, Mr. Sizer's out on an ROR for possession of cocaine. He also, since he picked that up, he also got arrested for and pled out a drug paraphernalia. He's got a 2010 felony theft, 09 grand theft, theft 09, cocaine 07, grand theft 99.
The only thing I will say is, in reviewing the PC affidavit, he gives a post-Miranda confession. I believe when he was stopped initially by the Deputy Mateo, he voluntarily comes back in the store. So what that shows me, he's being cooperative with law enforcement officers. I understand that he's currently out on a drug-related offense, so what he picked up is not related. It's not similar to the case he's currently out on. So, Judge, I'm going to be asking for the court to consider releasing him on pretrial release with random drug testing.
All right, I'll grant that.
Thank you.
Spanish interpreter is present, Your Honor.
Okay, one moment, please. All right. All right, good afternoon, Mr. Jellin. So can we have Wilmer Rojas Gamboa?
Excuse me.
Conti, Your Honor.
Okay. All right, sir, interpreter, you raise your right hand. You swear to translate from Spanish to English and English to Spanish.
I do, Your Honor. For the record, that's Igor Felicioni.
Good afternoon, Mr. Felicioni. Okay, Mr. Gamboa.
Señor Gamboa.
Good afternoon, sir.
Buenas tardes, señor.
All right, before
Good afternoon.
Mr. Gamboa has 2 counts of burglary, unoccupied dwelling unarmed that was presented. Are you standing in for his attorney, or
Mr. DeCobo is his lawyer. He asked me to stand in today. We spoke to Mr. DeCobo earlier.
He has to translate.
Yeah.
At some point. El señor Gamboa tiene 2 cargos de robo de una morada desocupada armado. Este es su abogado que está representando al señor Dacobo. Hablamos con el señor Dacobo el día de hoy.
I spoke to Mr. DeCobo, as did Mr. Linder, the state attorney. We spoke to him on the phone earlier.
Yo hablé con el señor Dacobo, así como también el señor Linder, el fiscal. Hablamos por teléfono.
So this one's a little confusing because I guess it involves both statewide and the state attorney's office.
Y es un poco confuso porque incluye la Fiscalía del Estado y del Condado.
In any event, the older case from 14, Mr. DeCobo, in his conversations with all the parties, believes that should be null prost. However, that is not what Mr. Linder's doing today. I think he's agreeing to ROR him on the older case from November.
El caso anterior el caso más viejo, el señor Dacobo considera que debe ser anulado, pero no es lo que está haciendo el señor Linder el día de hoy.
So, Your Honor, I didn't know about that this case had been reset until I got to court on Monday morning.
Señoría, la Fiscalía no estaba al tanto de que este caso había sido reagendado hasta que llegué a la corte el día lunes.
I've done my best to catch up.
Estoy haciendo lo mejor para entender qué está pasando.
I spoke extensively yesterday with Assistant Statewide Prosecutor Stephen Amash about this matter.
Hablé con el fiscal del estado a grandes extensas el día de ayer acerca de este asunto.
He prosecuted Mr. Rojas Gamboa in 2015 in the Dade County case.
Right.
Él fue quien procesó al señor Rojas Gamboa en el caso del 2015 en el condado de Dade.
Now, on charge number 1 before the court, and I'm referring specifically to arrest warrant 15291 AF10.
Ahora, sobre la orden de arresto número 1, me refiero a la 15291 AF10A.
Okay.
The allegations that make up the basis for the arrest warrant
Los alegatos que son la base de la orden de arresto
was part of the prosecution in the 2015 statewide case.
fue parte del caso de la fiscalía en el caso del 2015.
It specifically made up one of the predicate incidents on his racketeering charge.
Hablaba de uno de los incidentes predicadores del cargo de raqueteo.
And he was also charged for an individual count of burglary based on that offense.
Y también fue cargado por un cargo de robo en esa oportunidad.
In light of that, while I am not in a position to announce no information at this time, I am asking that he be ROR'd on charge number 1.
A la luz de eso, a pesar de que no estoy pidiendo que se anule el proceso, la Fiscalía sí estaría de acuerdo con que el señor fuera liberado bajo su propio reconocimiento.
As far as charge number 2, arrest warrant 15357 AF10.
Okay.
Con respecto al cargo número 2, la orden de arresto 1535 AF10.
I reviewed the entire information from the statewide case and then spoke with Mr. Amesh.
Revisé la información del caso estatal y hablé con el señor Amesh.
The allegations that serve the basis for that warrant are not contained anywhere in the 2015 prosecution.
Los alegatos que son la base de esa orden no están contenidos en el caso del 2015.
So my understanding is the state can still prosecute him at this point in time on that burglary of a dwelling.
Entiendo que entonces la Fiscalía sí podrá presentar cargos en su contra por ese cargo en particular, por ese caso en particular.
Is it going to be the state or is this going to go back to the statewide prosecutor?
¿Va a ser la Fiscalía del Condado o del Estado?
My understanding at this point in time, Your Honor, my office would be reviewing this matter to determine how to proceed.
Entiendo que sería la oficina de la Fiscalía del Condado quien manejaría este asunto.
And I have spoken with our Assistant State Attorney in charge of felony case filing to bring this case to his attention.
Y yo hablé con nuestro fiscal para traer el caso a su atención.
Your Honor, at this point in time, Judge Porth had set a $250,000 bond on count 2.
Su señoría, en este momento el juez Porth fijó una fianza de $250,000 en el cargo número 2.
I am going to be requesting that the court keep that bond in place.
Yo voy a solicitarle en este momento a la Corte que mantenga la fianza tal y como está.
And should that bond be posted, that Mr. Rojas Gamboa be supervised by pretrial release with a GPS monitor level 2.
Y que si el señor Rojas Gamboa llegase a pagar esa fianza, que se mantenga bajo la supervisión de PTR con un monitor nivel 2 de GPS.
Your Honor, I don't know if you had an opportunity to see the information that the statewide prosecution prepared.
No, Mr. DeCobo, when he was here on Friday, he tried to tell me, and actually he did also try to call he called the statewide prosecutor, but none of us, neither him nor I, had any paperwork to look at, so that's why it was reset for today.
Su señoría, no sé si tuvo una oportunidad de ver la información que tenía la Fiscalía Estatal. No, yo hablé con el señor Dacobo y él llamó al fiscal estatal, pero ninguno tenía la información que pudiéramos ver sobre este caso.
Understood. Your Honor, as I know the court's read the 2 arrest warrants, so you are familiar with the allegations as far as Broward County with these 2 burglaries.
Su señoría, yo sé que la Corte ha leído ambas órdenes de arresto y por lo tanto asumo que usted está familiarizada con los alegatos de robo en el condado de Broward.
As I'm sure once the court heard the word racketeering, I'm sure the court recognized that this also involves part of a major, in 2015, a grand scheme involving burglaries around multiple counties.
Y estoy seguro que cuando su señoría escuchó el cargo de robo organizado, se está al tanto de que fue una operación importante en el año 2015 en todo el condado.
Mr. Rojas Gamboa was actually sentenced to 42 months in Florida State Prison as a resolution of the statewide case.
El señor Rojas Gamboa fue sentenciado, de hecho, a 42 meses en una prisión del estado de la Florida como una manera de llegar a un arreglo en el caso.
So these are significant allegations.
Por tanto, son alegatos significativos.
Additionally, Your Honor, I would note that while he doesn't have a detainer on him at the moment, an immigration detainer on him at the moment, Mr. Rojas Gamboa is facing deportation.
Y quisiera agregar que a pesar de que no hay una orden de detención de inmigración en los momentos por el señor Gamboa, para el señor Gamboa, él se está enfrentando a una potencial deportación.
Should he be released from custody prior to ICE being able to take custody of him to deport him, the state has a concern about him being a flight risk.
Por tanto, si nosotros lo liberamos, la Fiscalía tiene una preocupación con respecto a que el señor sea detenido que sea detenido por ICE y que por lo tanto él es un riesgo de huida.
And avoiding not only potentially prosecution on this case, but deportation.
Y al huir evitaría que se le presionaran los cargos en su contra en este caso, así como también evitaría que fuera deportado.
Obviously there are a lot of moving parts in this case, Your Honor.
Es un caso complicado, su señoría.
That's why I'm asking the amount that Judge Porth said be kept in place so that a more thorough bond hearing could be held in front of whatever judge this case is assigned to.
Por tanto, estoy pidiendo que la fianza que fijó el juez Porth permanezca tal y como está, de manera tal que se pueda hacer una audiencia en el futuro más a fondo sobre la fianza con cualquier juez al que le toque hacerla.
And obviously the GPS is to counteract any risk of flight.
Y el GPS sería para contrarrestar cualquier intento de escaparse.
Thank you, Judge.
So, the 42 months, was that completed, that sentence?
¿La sentencia de 42 meses fue completada?
Yeah, sí.
Okay, so it sounds
Yes.
it sounds like statewide did their job and that this fell through the cracks and now you want to hold them on a $250,000 bond. Is that basically what I'm hearing?
Entonces me parece que la Fiscalía Estatal hizo su trabajo, él hizo su tiempo, este caso se cayó por los huecos y ahora quieren mantenerlo en una fianza de $250,000. ¿Eso es lo que me están diciendo?
And my understanding is statewide had reviewed this case as well and decided not to include it in their original prosecution. Is that accurate as well, Mr. Linder?
Entiendo, señor Linder, que la Fiscalía no había revisado este caso y no lo había incluido en su caso. ¿Correcto, señor Linder?
And Your Honor, Mr. John he's free to make whatever argument he makes, but I don't believe I'm in a position.
Well, you're laying a record. Maybe we should hear the full record. But the last question is, was Judge Porth aware of all the statewide activity prior to reading this warrant and assigning such a high bill? Was he aware of the prison sentence, the prosecution, whatever the deal was? Did he know any of that when he set this bond?
Mi pregunta es si el juez Porth estaba al tanto de alguna de las averiguaciones y acciones de la Fiscalía Estatal cuando él fijó esta fianza. Esa es mi pregunta.
Because now it sounds like we're just insult to injury here. He's done his time, he made his deal, and now the state attorney wants to jump in here and handle this case like it's not something that's already been fully, part of something that's been fully reviewed and dealt with by the criminal justice system. So if I'm correct in my questions, if the state chooses not to answer, that's fine.
Well, you know this is not an adversarial hearing,
Well,
Mr.
okay,
Gilling.
but it is a fairness issue as well as the fact that you are entitled to hear the full picture before making your ruling.
Your Honor, I'll be more than happy.
Interpreter needs at some point to interpret.
Yes.
Entonces, la pregunta es, me parece que este señor completó su tiempo, hizo su trato con la Fiscalía y ahora quiere venir a la Fiscalía y tratar este caso de una manera diferente. Por lo tanto, entonces, no sé qué está pasando con el sistema criminal de justicia. Este es el momento que yo le preguntaría. Él es libre de responder mi pregunta si quiere o no quiere. La juez le indica al abogado que esto no es un proceso adversarial, esto no es un coloquio.
Okay, Your Honor, I'll be more than happy to answer Mr. Jones' questions. First, as far as what Judge Porth knew or didn't know when he signed a warrant.
La Fiscalía estaría más que feliz que responder la pregunta del señor Jones. Primero, con respecto a si el juez Porth sabía o no sabía, no estaba al tanto de los pormenores del caso.
As I'm sure Mr. Jones knows, I wasn't present when Judge Porth signed the warrant.
Estoy seguro que el señor Jones sabe que yo no estaba presente cuando el juez Porth firmó la orden.
So I'm sure Mr. Jones also would know and realize that I have no idea what Judge Porth knew or didn't know.
Por lo tanto, el señor Jones puede inferir que no tengo ni la menor idea de lo que el juez Porth sabía o no sabía.
That being said, I'm sure Mr. Jones could have asked counsel he's appearing on behalf for when Mr. Gamboa was sentenced by his judge in Dade County.
Entonces estoy seguro que el abogado que está representando ahorita, el señor Gamboa, pudo haber hablado con el abogado y preguntarle cuándo fue sentenciado el señor Gamboa en el condado de Dade.
21/9 días. Dígale que fui sentenciado el 20. Fui sentenciado el 21 de septiembre del 2018.
Please tell him I was sentenced on September 21st, 2018.
Was just about to.
Estaba a punto de decir eso.
which means since Judge Porth signed the warrant in 2015, he couldn't have known.
Okay. So
Víctor,
that's my point.
Counselor,
I
lo cual implica que el juez, al haber emitido la orden, no podía haber sabido lo que había ocurrido en el caso en el momento.
That being said, because he was never prosecuted for the allegations on the arrest warrant that Judge Porth signed,
Visto eso, como él nunca fue procesado por los alegatos de la orden que firmó el juez Porth,
any concerns that Judge Porth had about the seriousness of the allegations still exist.
cualquier preocupación que pudo haber tenido el juez Porth acerca de la seriedad de las acusaciones todavía existen.
Sure.
Okay, so Judge Porth didn't know about all the stuff that you just alerted Judge Powell, the concerns with racketeering and all that stuff. But since Judge Porth signed that warrant and signed that high bond, they've been addressed by a prosecuting agency, and he's been prosecuted.
No, not for this case.
Not for this one case.
Yeah.
But everything else that Judge Porth was alerted to with racketeering and all that you were talking about has been dealt with. You just told Judge Powell that there were
Judge,
concerns.
I'm sorry. This is, I mean, if Mr.
Sounds
Jones
like
wants to
it's
address the
just-
court, that's fine, but I feel like he wants me to be on the stand to question me.
That's what I
I'm not a
heard.
witness
I
in
don't
this
know what you
case.
heard, Judge. But basically, since then.
So, all right, so I this is totally gone left. This is not what Mr. DeCobo, I guess, anticipated. Let me finish. So, right, and so here we are. That's not the case. One,
I'm sorry, Your Honor, but it's a lot of give and take.
all right, so I'll start over.
Thank you, Your Honor. I appreciate it.
This, last Friday, when this, Mr. DeCobo was here on this case,
El viernes pasado, cuando el señor de Cobo estaba aquí en este caso,
this was not what we anticipated,
esto no era lo que estábamos anticipando.
which is exactly why I asked for the parties to go back and have a conversation with the statewide prosecutor
Que es por lo cual exactamente por lo cual le pedí a las partes que hablaran con
to
el fiscal
determine,
estatal para determinar
the status of these charges.
el estatus de estos cargos.
All right. Today, I'm being told that count one it's agreed that count one has already been part of the statewide prosecution.
Hoy me están diciendo que el cargo número 1 se acordó que ha sido parte del procesamiento de la Fiscalía Estatal.
Count two, which it seems like it's Judge Porth and Judge Elijah Williams who are signing the affidavits and the warrants on this. Yeah.
Y el cargo número 2, que parece que hubiera sido firmado por el juez Porth y el juez Williams, las órdenes de arresto.
And I think that might have been put down in error, Your Honor.
You think?
If you look at the first warrant, that was clearly Judge Haynes that signed it.
No, right. I'm not talking about the other case.
And then the second one,
I'm talking about 150357.
yeah, it looks like
Su señoría, la fiscalía indica que quizás eso fue un error porque pareciera que fue el juez Porth y el juez Ames. No, le estoy hablando del primer caso. Estás hablando del primer caso. Estoy hablando del caso 150357.
it looks like Judge Williams signed off on the affidavit,
Okay.
and then Judge Porth signed off on the warrant.
Okay.
Parece que el juez Williams firmó la orden de arresto y el juez Porth la declaración jurada.
So this is first appearance court. And I believe that there are matters that need to be taken up with the presiding judge, whether there needs to be a motion to dismiss.
Esta es corte de primeras apariciones y hay asuntos que hay que hablar con el juez que está presidiendo sobre el caso, como peticiones para desechar, cosas así.
Or whether the state is going to null pros, I don't know.
O si la fiscalía va a anular el proceso, eso yo no lo sé.
No, I understand.
So for my purposes here today, I am going to find probable cause. And the state has already indicated that count one needs to be ROR'd, because there needs to be an evidentiary hearing. You would agree?
We just, again, we know you're not gonna, that nothing will be dismissed on count two, but obviously, given that all this has happened since that original bond was assigned, at this point, you have a single, one count burglary.
Right.
And ask you to set the standard bond. It's obviously, there's been so much that's gone on with this. Since then, the states argued their position, which, again, now that we know that everything has happened, there is no way in the world some judge reviewing it independently with the full facts before them would assign essentially a no bond hold, tantamount to a no bond hold. So we're asking you to set the standard bond on this charge. If ICE wants it, as Mr. Linder said, they'll stop a hold on them, and that'll be that. So we would agree that if you want to put the monitor on, fine. Put a $2,500 bond with the monitor.
And just so, I'm sorry,
Ok, hemos entendido que la juez indica que en este momento, basándose nada más en lo que ella mantiene competencia, ella va a fijar que hay causa probable y que la fiscalía acepta que por el cargo número 1 se le libere bajo su propio reconocimiento, y evidentemente para el cargo número 2 permanece la fianza original. El abogado de la defensa indicó que, visto que estamos hablando de una persona, de un caso que ha pasado muchas cosas, y una persona que está enfrentándose a un cargo de un robo simple, debería de ser asignada la fianza estándar para un caso de estos sistemas, de este tipo, que es de $2,500 por la fianza.
and just so the court's aware, I actually learned a lot about this regarding immigration issues yesterday. There is a final deportation order.
Para que la corte esté al tanto, hay una orden de inmigración, de deportación final de inmigración que está pendiente.
The reason that there is not a detainer hold on him right now is because, well, I'll translate here.
Go ahead, Mr. Lander.
Okay, because the jail only accepts detainer holds when they're signed by an immigration judge.
La única razón por la cual no hay una retención de la inmigración en este momento es porque la cárcel solo acepta retenciones de inmigración cuando son firmadas por jueces de inmigración.
And in this instance, his detainer order is signed by an ICE officer. Apparently, there are two ways that orders can be issued for detainers.
Y parece que la orden en este caso fue firmada por un oficial de ICE.
Okay, based on the warrant that I've reviewed, I am not going to make any changes today as to the bond that was attached to the warrant. It's $250,000, and I'm sure there'll be a hearing before the division judge with all the other conditions, the GPS level 2.
Set when everything else was unresolved. Everything's been resolved since then. Essentially, you know.
I need to look at the one thing at the time that it was before me.
Yes.
Mr. Judge.
The state did report that the vast majority of that stuff was resolved.
I'm looking at that one case that was before Mr. Jellin.
All right. Excuse me, what was that last part you said?
I said I'm looking at the one case. I'm not looking at all the other cases. I'm looking at the one case that was before.
Ok, basado en la orden que yo tengo, no voy a hacerle cambios a la fianza, queda fijada en $250,000. Luego habrá una audiencia con el juez de división para referirse a ese asunto y a las otras condiciones de liberación, como el GPS, etc. El abogado de la defensa indicó, pero su señoría, esa fue una fianza fijada cuando no todos los asuntos estaban resueltos. Hasta ahora, hasta por la misma admisión de la fiscalía, la mayoría de los asuntos quedan resueltos. A lo cual la juez respondió, yo estoy mirando a este caso en sencillo y queda así fijado.
So can you just explain that the further conversation with statewide has to be had just to get this resolved?
Necesitaremos tener más conversaciones con la Fiscalía Estatal para que pueda ser resuelto este caso.
Okay?
Okay?
¿Cuándo es mi última corte, la próxima corte?
What's my next court date?
It has to be set with, which judge is it, Mr. Lawyer? Do you know?
We won't know until the clerk's office now takes the paperwork and randomly assigns the judge.
No lo sabremos hasta que la oficina de la Secretaría asigne al juez de manera aleatoria.
It should be shortly, okay?
Debería ser en breve, ¿ok?
Gracias.
All right, thank you.
¿Cómo hago para hablar con el abogado Jacobo?
How do I get to talk to my attorney, Mr. Jacobo?
I'll tell him to come see you. Okay?
Yo le digo que te vaya a ver, ¿ok?
Gracias.
Thank you.
All right. Who do we have? Is there anyone else who needs a Spanish interpreter?
¿Alguien más necesita la asistencia de un intérprete español?
All right,
Not at me, Judge.
thank you.
Have a good day, Your Honor.
You too. All right, where are we now? Where do we, huh? Yeah. But where were we on the hearing docket? Demetrius Mathis?
Mr. Demetrius Mathis is here present, Judge, at me.
All right, Mr. Mathis was before the court. What page is he on?
4.
Oh. I have that one too well. Thank you. All right, Mr. Mathis has $3,500 bond. All right, I'll hear from,
Judge, Mr. Mathis is 18 years old. The only person that could post his bond is his grandmother, who he lives with. Now, she works, but from what Mr. Mathis can only imagine, that she's not able to afford the $3,500 bond. Now, Mr. Mathis is also working. He works full-time at McDonald's. He believes his job is still available to him. So, Judge, we're going to be requesting that the court consider releasing Mr. Mathis on pretrial release.
And, Your Honor, I would be opposing. I showed Mr. Reedy and then I provided the court with a copy of his juvenile history. As you can see, he's currently on probation for felony theft-related matters. Bless you. He has violence in his past as a juvenile, so.
Judge, if that's a concern to the court, because, and understandably it would be as far as his juvenile priors, I'm asking then if the court's is reluctant to release Mr. Mathis on standard pretrial, then we're going to be asking for the court to consider placing him on level 2 pretrial.
how long, Mr. Mathis, how long have you been working at McDonald's?
For a year.
1 year?
Yes, ma'am.
And what days do you go to work? Is it a schedule?
Yes, I go to work on Tuesdays, Wednesdays, Fridays, Saturdays, and Sundays.
Okay. From what time to what time? When do you begin?
On Tuesday and Wednesdays, I go from 10 to 6. Friday is 12 to 8. And on Saturday and Sunday, it's 6 p.m. to 2 a.m.
All right. Are there other siblings in the house? Do you have brothers and sisters?
I don't live with them.
It's just you and your grandmother?
Yes.
All right, I'll grant the level 2 pretrial supervision.
Thank you, Judge. Good luck, sir.
All right, Melvin Henderson.
Mr. Henderson is here, present, Judge at main. Come on up, sir.
Mr. Henderson. All right, what's the deal with Mr. Anderson?
Judge, he's here on a felony petty theft on a $750 bond. No one's going to be able to post his voluntary bond. My understanding is this involves cologne taken from Dillard's. He gives a post-Miranda statement, so he's cooperative with law enforcement. The bad thing about it is, as far as financially, he's indigent. He's homeless at this time, and he owns no money. No property. Has no money to post his bond. He's 50 years old and been living here since 1997. So, Judge, we're going to be asking for Mr. Henderson to be released on pretrial release.
All right, I'll grant pretrial release.
Let me give you a map of pretrial. You're going to be released today. You're going to be closed by the time you get out. You have to report there first thing tomorrow morning. Okay. Okay.
All right. That's it.
Thank you, Judge.
All right.
All right, thanks.
You're welcome. Jamar Anderson.
Conti.
Conti.
All right, Mr. Anderson was arrested on March 1st over the weekend, and so he's back for a second look. He has $2,100 worth of bond. Jamar Anderson.
$2,100 bond that he can't make, Judge.
Yeah, please. Just see what you can find on BS
Looks like a total loss of $299.49. Do you have a place to go, Mr. Anderson?
Yes, I do.
Who would you be living with?
Yes, I live in Dade County.
Who do you live with?
I live alone.
How long have you lived at that location?
Since November.
Are you working?
I'm starting a new position this week. I was supposed to start on Monday, actually.
What type of position?
It's construction for coastal.
Judge, it sounds like he has a place to stay. He has a job. Depending on his record, I'd ask for pretrial release.
What kind of record does Mr. Anderson have?
Getting hits at, let's see. Getting hits out of Virginia, Maryland, and New York. Failure to appear, 2016 out of Virginia. Arrested on a fugitive warrant, 2016 in Virginia. Another failure to appear, 2016 in Virginia. Identity fraud, 2016 in Virginia. Arrested on another fugitive warrant, 2015. Out of Maryland. Arrested in 2016, failure to appear. Another failure to appear, 2014. And under the name Terrence Tolliver out of New York, a aggravated DWI, 2011.
All right, I'm not going to make any changes at this time. The bonds will remain in place. All right, Matthew, yes. Matthew Kirby.
Mr. Kirby is here present, Judge at Maine. He is approaching. Come on up, sir.
All right. Mr. Kirby has $1,000 worth of bond.
That is correct, Judge. 500, 500. I believe his bond was reduced. The only thing I can imagine, Judge, Mr. Kirby basically has a clean record. He did advise me a couple traffic speeding tickets. He's been living in South Florida now for 4 years. Judge, at this time he's working. He works at the Outback Steakhouse where he's been there for 1 year. And from what he advised me, he's been doing so well and impressing his supervisors that he's on his way to becoming a manager. Now, that's something very important to Mr. Kirby. He knows that, unfortunately, because he is here, he doesn't want to risk losing that opportunity, so he really much wants to try and be released. Now, we do realize this is drug offense, so we wouldn't have an objection if the court were to impose pretrial with random drug testing. Or ROR if the court's inclined.
Does Mr. Kirby have any priors?
Checking that right now, Judge.
Okay. Yes. Oh. Oh, I missed so many.
That's interesting. I'm showing an open drug charge out of Dade County and a driver's license suspension for refusal to submit to a breath test from June of last year.
He was also recommended for a SAP program on, I think Judge Izquierdo. He was before Judge Izquierdo over the weekend.
I'm almost done. I'll be done with it in June. I've paid all the money. I've done everything.
My understanding, Judge, in reference to the Dade case, from what Mr. Kirby has advised me, he's taking care of that issue. Judge just wants to be released because no one can come up with the $1,000 bond, so that's why we're asking for pretrial random drug testing.
I don't have a problem with that. I was really bringing it up more in response to Mr. Kirby's request for an ROR.
No, right, no. All right, I'll grant the pretrial with random testing.
Thank you, Judge.
And then we have Travion Thomas.
Mr. Thomas is approaching. He's approaching, Judge.
All right, Mr. Thomas was also in court this weekend.
That is correct, Judge. He has a $5,000 bond.
Whereabouts,
Judge, we're going to be asking for the court to consider releasing Mr. Thomas on pretrial release. He's 22 years old. He is looking for work. He lives with his grandmother in Lauderhill. From what he advised me, his grandmother has heart problems, so she relies on Mr. Thomas for help. He's currently looking for employment, and from what he advised me, that his grandmother's not going to be able to afford the $5,000 bond. So that's why we're requesting the court consider releasing Mr. Thomas on pretrial release.
So what priors does Mr. Thomas have?
Your Honor, 2017, resisting without violence. In 2011, in 4 separate cases, he was convicted of aggravated assault with a firearm. He violated probation, obviously, in all cases, and was sentenced to 2.5 years in state prison.
All All right, at this time, I'm going to deny making any changes as to the bond.
Judge, would you consider this? Now, I know last time he got arrested on a felony offense was about 8 years ago. Judge, would you consider releasing him on level 2 so that way pretrial would have to call his grandmother to verify, and if they verify, he'll be with a monitor?
All right, level 2, GPS.
Thank you, Judge.
And random testing. All right, Marcus Hicks.
Mr. Hicks is approaching, Judge.
How you doing, Your Honor?
I'm doing okay, Mr. Hicks. Mr. Hicks is Mr. Hicks before the court for a second look? How much is his bond?
His bond is $1,000. It's a grand theft, and I'm assuming the court's read the PC and probably has some concerns because it's not your typical grand theft. But what I did want to point out in reading the PC affidavit is thanks to Mr. Hicks' cooperation, he informed, I believe, law enforcement where to locate certain belongings that belonged to the victim, where she ultimately recovered. So he told him where to locate certain merchandise, and then other merchandise was recovered from Mr. Hicks' person. So, from my understanding, reading the PC affidavit, Mr. Hicks did give back everything. Also, Judge, he did give a full confession, so he cooperated with law enforcement. Having said that, Judge, he's been living here his whole life. He's 23 years old. Unfortunately, he's homeless. Now, he does have a mailing address of his sister who resides in Fort Lauderdale, as far as where he can use to as an address to get future court notices so he can appear to court. So, Judge, at this time, we're going to be asking on this third-degree felony to consider releasing Mr. Hicks on pretrial release.
What kind of prize has Mr. Hicks at?
Let's see. Theft 2018, theft 2015. I'd have to check to see if there's out-of-county priors. I would know, yes, he did tell law enforcement they could find the property. It was in a garbage in a public bathroom where he threw it. So now the owner of that property gets to have all her property back after it's been in a public garbage can. Lucky her.
I'll release Mr. Hicks to pretrial with a GPS.
Judge, unfortunately, we appreciate that, but he's homeless. He doesn't have a location, so they're not going to be able to verify any address, so it's going to be here.
You did say that. All right. All right, he'll standard pretrial.
Thank you, Judge.
Thank you, Your Honor.
You're welcome, sir.
Judge, we're done here at Maine, except for this gentleman that's the last one from the regular docket, municipal ordinance.
let me just handle Mr. Bush, because I don't... Mr. Bush, come on up, because I don't think anyone's coming. Mr. Bush, Mr. Bush, you have a municipal ordinance matter for trespassing. What do you want to do with this case, sir?
No contact.
All right, I'll accept your no contest plea and I'll sentence you to adjudication and time served.
Okay, thank you.
All right, do you have anything else holding you in custody?
No, ma'am.
All right, good luck, sir.
Thank you, Judge. See you tomorrow.
All right. So where is Cedric Coney? Oh, okay. And then, do we still have a misdemeanor docket? There's only one person, Terrence Walker at North Broward. Mr. Walker for trespassing. I remember Mr. Walker's case. Were we doing something with Mr. Walker?
The state offered me a 5-day offer. If you follow the offer, you're on kept the bond in place and then that for the second year. State's offers time served.
Oh, I do remember.
Is that what you'd like to do, Mr. Walker? Time served?
Yes.
Okay.
All right, Mr. Walker, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down, sir. Do you understand what's going on here today, Mr. Walker?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
And do you need more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Yes.
All right. What plea do you wish to enter?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given, and I sentence you to adjudication and time served. Good luck, sir.
Thank you.
All right. All right. Is that now it? All right, thank you, everyone.
Thank you, Judge. We will